Anytime. We welcome everyone to this morning's hearing on undue influence, Operation Higher Court, and politicking at SCOTUS. Before we begin, I'd like to remind members that we have established an email address and distribution list dedicated to circulating exhibits, motions, or other materials that members might want to offer as part of today's hearing. If you'd like to submit materials, please send them to the email address that has previously been distributed to your offices, and we will circulate the materials to members and staff as quickly as we can. I will now recognize myself for an opening statement. Lobbying is a term we hear frequently in Washington, D.C. There is an entire industry built around advocacy, outreach, and influencing policymakers and government officials. To limit abuse and to give the American people transparency into the legislative process, the lobbyists who meet with members of Congress and their staff must carefully monitor, track, and file disclosures regarding their interactions. And the lawmakers themselves have extensive disclosure requirements when they are treated to gifts, meals, and travel. The same applies to the executive branch. But those who meet with Supreme Court justices who have a life term have no similar ethical requirement. Those who lobby them can pay for justices' meals, vacations, and conference travel, and do so without letting anyone else know. And the justice's own financial reporting obligations are severely lacking. We rarely associate the term lobbying when discussing the Supreme Court, or influence, or advocacy beyond the limits of briefs, motions, and oral arguments, all placed on the record. The Supreme Court is an institution meant to be beyond both influence and reproach, held in esteem by the general public, and one governed by the facts and laws argued before it. Unfortunately, as we will hear today, that might not always be the case. The court may in fact be susceptible to outside influence and lobbying. Recent reporting has uncovered a sophisticated covert lobbying scheme known as Operation Higher Court that operated behind the curtain at the Supreme Court for more than 20 years. One of our witnesses, Reverend Schenck, will describe how his organization worked with donors to develop long-term relationships with the conservative-leaning members of the Supreme Court to move them farther right on faith-based issues. This quiet lobbying by what he terms stealth missionaries generally began as encounters at events held by the Supreme Court Historical Society and evolved to include private dinners and even vacations with justices and their wives. These were not merely social occasions. They had an explicit mission to encourage the justices to resist compromise and to take hardline stances on priority faith-based issues such as abortion, religious accommodation, and same-sex marriage. Reverend Schenck's organization identified conservative Christian justices enjoying a life term who they believed may be sympathetic to their organization's beliefs. His supporters then sought to use this shared faith to infiltrate the justices' social circles and to push them further to the right, away from compromise and towards more extreme legal positions. Access to abortion care, contraception, gay marriage, in all these areas critical to Reverend Schenck's ministry, he sought to encourage the justices to use their faith to decide America's laws. In his written testimony, Reverend Schenck testified that even he believed the justices viewed Roe v. Wade as settled law. But this did not stop him or his supporters from lobbying specific justices, urging them to undermine women's access to basic medical care. These efforts, whether through private group prayer sessions, intimate dinners, or lavish trips, ultimately bore fruit when Justice Alito delivered his decision in Dobbs, overturning Roe v. Wade and putting women's health care across the country in peril. We are now left wondering how much of this decision, upending decades of established precedent, was influenced by the organized wealthy donors lobbying to move the conservative justices to the right. To be clear, no one in this story, neither Reverend Schenck nor his supporters nor the justices of the Supreme Court, broke the rules. And that is the problem. If the Supreme Court were subject to a code of ethics like the rest of the federal judiciary, and like the legislative and executive branches, they would need to follow basic financial disclosure reporting, gift rules, and recusal guidelines. And they would need to ask of themselves what every employee of Congress, of the White House, and of the federal courts asks. What is the nature of this friendly dinner? Is someone asking something of me? Many in Congress and in the media have focused on the revelation that one of Reverend Schenck's stealth missionaries received advance word of the Hobby Lobby decision, allegedly from Justice Alito himself. While this breach of trust was undoubtedly a serious incident, made even more troubling in light of the leak of the Dobbs opinion earlier this year, it should not be the key takeaway from Reverend Schenk's story. The moral of the story is this: Supreme Court justices cannot effectively self-police their own ethics, and we shouldn't expect them to. Without established guidelines, at best we leave justices with the impossible and exhausting task of evaluating ethics without a clear standard. And at worst, we have justices accepting overtures from individuals seeking to influence the court with little to no transparency. Ethics should not be a partisan issue. In 2018, this committee passed by voice vote legislation sponsored by Congressman Issa that would have created a code of ethics for the Supreme Court. Our colleague, Congressman Hank Johnson, has since introduced similar legislation. I sincerely hope that we can all work together to pass legislation that would help restore America's faith in our highest court. I now recognize the ranking member of the Judiciary Committee, the gentleman from Ohio, Mr. Jordan, for his opening statement.
Thank you, Mr. Chairman.